platform. Virtual discussion in judicial independence of by. So before starting the discussion, I'll just request each of you to please unmute your microphone so that the speakers, you can hear the speakers very clearly, and then only you will be benefited by it. On the virtual dais, we have very eminent lawyers of Supreme Court and High Court, and the dignitaries on the virtual dais are Mr. R. Venkataramani ji, Senior Advocate, Mr. V. Sekhar ji, Senior Advocate, Mr. Harshvir Pratap Sharma ji, Senior Advocate, Mr. Dinesh Agnani, Senior Advocate, Mr. Vivek Sood, Senior Advocate, Mr. Vivek Reddi, Senior Advocate, Mr. Ajit Kumar, Senior Advocate, Mr. Vikrant Yadav, Mr. N Verma, Mr. N Verma, Mr. Ajay Singh, Mr. Balendu Sekhar. Sir, I welcome you all on the virtual dais, and I'll request Puji. Ripuji, you have logged in?
Yes. I'm here.
Please, I'll now ask Ripuji to give the welcome address. Over to you, Ripuji, over to you.
Greeting to all my seniors, my colleagues. First of all, let me introduce our group which is behind this program. The Delhi Advocate Group has been formed by a group of like-minded lawyers who believe that institutions are more important than individuals, believe in constitutional ideals, and endeavor to protect its basic structure. Today, we are in this webinar to discuss a very important issue, that is daunting the country and its institutions. We are seeing a trend wherein a lobby of persons or political entities, if they do not get an expected and desired result from an institution, they start a program of slander against that particular institution. Today, our judiciary is also. We, as a member of the bar, owe a responsibility to uphold its independence and dignity. Today, we have a panel of esteemed speakers with us to guide and elucidate us on this burning issue. I welcome everyone in this program to throw light on this issue. We have with us legal luminaries like R. Venkataramani ji, V. Sekhar ji, Dinesh Agnani ji, Vivek Sood ji, Vivek Reddi ji, Ajit Kumar ji, Vikram Yadav ji, Neeraj ji, Ajay ji, N Verma ji, Balendu Sekhar ji, and further all our esteemed guests who are attending the program are also welcome, and we look forward to the guidance of our speakers. Thank you.
Thank you, Ripuji. Now, may I invite Mr. R. Venkataramani ji, Senior Advocate, Supreme Court of India, and former member, Law Commission of India. So before I invite, I'd like to say a few words for him, though he doesn't require any introduction, but sir, forgive me, I have to take that initiative. Mr. Venkataramani ji is the first generation advocate. He is a graduate of Government Law College, Puducherry. He has completed over 40 years of practice at the Honorable Supreme Court of India. Sir enrolled as an advocate in the year 1977, practiced to the Supreme Court in 1979 under the tutelage of late Mr. P.P. Rao. Sir has served 2 consecutive terms as a member of the Law Commission from 2013 to 2016. Sir, I welcome you on this virtual dais to say on this topic. Please, sir.
Thank you so much. Thanks for the invitation from the organizers. And let me greet and welcome those who logged in. Looking forward for an evening discussion on a subject of everlasting importance. Ideally speaking, I should have come at the end of the long list of very learned speakers who have been listed. And what happens when you gather to discuss subjects such as this? And more importantly, not in a physical space, in the virtual space. Now, I want to tell you, in 1950, when the Constitution of India was enacted, and then 2020, if somebody were to do a space-time travel from 1950 to 2020, particularly the Constitution makers, they would probably sit back in their chairs and think, is it the Constitution we have made? So go to any country where written constitutions have been enacted, be it the United States or even a recent, a nation state like South Africa, which is 1995-96 constitution. Or pick up some of those East European countries which have enacted constitutions post-collapse of the Soviet Union. And if you look at the large amount of literature which has been analyzed on the independence of judiciary, three or four important aspects emerge, I think, universally the entire human civilization. And one, why do we need an independent? And who guarantees that the judiciary is independent? And whether this guarantee will be through a constitutional process or through any other supporting legal process. And how far, regardless of the fact that we enact legislations and then enact rules and codes of conduct. You remember Justice J.S. Verma had his wonderful code of conduct for judges. And we have the Bangalore principles on independence of judiciary and the International Commission of Juries. So we need a number of documents which talk about independent judiciary. So whether a mere enactment of a set of rules on how institutions will function would be sufficient, or ultimately we fall back on this, namely, we call upon the resource of morality and ethics of every human being to be able to, independent, neutral, impartial, and an ethically strong human being. So these questions are both unconnected but are also related. But in contemporary times, when you're talking of independent judiciary, probably it looked very different from what when the US Constitution was enacted and they were talking of the US Supreme Court as an institution for dispensing justice, but before Marbury versus Balendu was decided, and the Supreme Court said judicial review is in our hands. So today, one important thing which has happened all over the world, courtesy constitutions being enacted, courtesy human rights having become part of the world, rights dialogue, and a wide range of such developments, that we now begin to talk in constitutional language. We no longer talk in language other than a constitution. Therefore, when we talk in a constitutional language, our everyday life, every aspect of our life, and every moment of our life is defined by what will be done through the Constitution, under the Constitution, and by means of the Constitution. These things have to happen in accordance with an orderly pace, and in order that whoever is entrusted the task of ensuring that Constitution functions do not undermine the Constitution, we always need some do's and don'ts. If you look back, for instance, in the history of independent judiciary in England for over 200 years, you have very interesting examples of erring judges and repeated attempts being made to ensure that corrupt judges do not become part of the judicial system. But virtually speaking, 100, 200 years of English history of independence of the judiciary and what is happening in the rest of the world, including the most claimed free world, free independent judiciary in the US, you will still find examples of judicial malfunctioning, judicial non-independence or judicial corruption and so on and so forth. So when you're talking of independent judiciary, we must keep them all in mind. As we see in the past, let's say, a couple of months, lots of interesting developments are taking place in our country. And in the name of, let's say, an independence of judiciary being challenged, or in the name of promoting one's freedom of speech, when we do cross lines, when we don't lay down independent norms for our individual behavior, then we are really testing the outer limits of every institutional functioning. Let us keep that in mind. When we test the outer limits of every institution's functioning, including institutions such as the Bar Council of India, and every lawyer being an institution by themselves. So I believe today, because of the challenges involved in every institution under a constitution called upon to perform very difficult and complex functions. It's very difficult to say a judiciary when in 1970s, Professor J.I.J. Griffiths wrote a book in England called The Politics of Judiciary. It was a great furore in English academic circles. He questioned the lack of impartiality of judges from a variety of points of view, namely ideological lack of impartiality. So therefore, why now that whether you select and by whatever process you select, whether it's by election or by selection, judges to superior courts, we entrust our entire responsibility of administrative justice in their hands. Do we have a magic by to ensure that this is done impartially, neutrally, without being subject to any influence? I don't think there are any magic answers to this. But we have a long traditions which judges do imbibe. We have a long set of stories and long set of rules which do inform us as to what should be done and what should not be done. So when you ask the question, independent judiciary and the role of the bar, only one thing comes to my mind. And again, having regard to my witnessing the growth of the bar in Supreme Court, I know the Supreme Court has transformed itself in the past 30 to 40 years. Two or three things come to my mind as challenging dimensions. One, let us say, look at the kind of issue that used to come to the court about 20 to 25 years ago. Mostly challenges to legislation, challenges to administrative law, challenges to governmental policy decisions, or civil disputes, criminal matters, so on and so forth. And but now, after let's say the late 80s, when the Supreme Court began to open up its doors to public interest litigation and to enable any citizen of the country to knock its doors for enforcement of fundamental rights, we have seen a complete sea change in the functioning of the court. If the sea change in the functioning of the court, whether it is necessary or not, whether it must have certain limitations or not, will be answered only in due course of time. But as I look at it, I think it is very important that certain fundamental changes have occurred in the functioning of the Supreme Court of India. And along with the same process, what has happened to the bar? We always think that the bar has certain ideal roles to play. I also know that these ideal roles are never played. And as I see the younger generation entering the bar in the past decade or so, several vexing questions come into their mind. They ask all kinds of questions about whether the perceptions about the functioning of the independent of the Supreme Court or the High Courts is really correct, or whether this kind of story they hear about the influences subject to which the courts are functioning are real or true or not are very difficult to answer. In 2008, I think the Bar Council of India set up a committee or a commission to find out a variety of issues relating to independent judiciary, including issues such as uncle judges, etc. And those kind of questions keep coming back. And they will keep coming, and they will be happening as long as we shy away from very important fundamental questions. Now, we have somehow evaded the question of an independent process of appointment of judges. And partly the Supreme Court is responsible for it. If you look at what happened in England from 1960 onwards, the question of an independence process or a mechanism for selection appointment of judges is still going on. But now they have probably reached a stage when a commission appointment of judges is more preferred than to any other politically weak or socially weak and infirm process. Therefore, that's a very important step to be taken. The second is, even though for more than 15, 20 years, the accountability legislations have been debated, we have not seen its emergence as a reality. The second thing. The third thing is, I've seen people, young members of the bar, either working with me as interns or joining with me for some time and breaking away. One important question they keep asking me is, sir, how do you explain that there's a growing perception among the general public that there is a possibility of influencing the higher judiciary through a variety of means? How do you answer that question? The question, why did the very perception arose at all? If there is a reason for the perception to arise, then I think we must analyze the reasons. I mean, without fear or favor. I don't think if you, as long as we postpone the analysis of these factors, as long as they postpone the analysis for the simple reason that we will fall foul a particular court, I think we are moving far and far away from examining the real causes of the lack of independence of judiciary. Therefore, the role of the bar, that I don't want to go into detail about what happened to a particular generation of judges and lawyers. I think that is unnecessary. And that will be done probably by a very impartial study or a survey. But what I want to share with you is this. There are several perceptions which are going around. These perceptions are not completely without any basis. And if certainly there are some basis or a source for this perception, we will have to undertake a real examination of these perceptions and the reasons for the perceptions. And I don't think this analysis will be guided by, let me be very frank, I don't think it will be guided by the involvement of the judiciary itself. It has to be a study, analysis, outside and away from the involvement of the judiciary as an institution. I'm not decrying the possibility of a contribution or even denying the possibility of a good contribution by judges. That's a different issue altogether. But if you're talking about a proper analysis, it must come from outside the court and from the bar and at a social level. And then therefore, we have a wide range of unconnected factors. As I said about the freedom of speech and expression. Or I said, what kind of role the bar will have to play today in ensuring the constitutional aspirations of all sections of people and ensuring that the constitutional promises are realized as early as possible, and also in ensuring it is done in an orderly manner. It's quite some time that the bar has become divided on political, ideological basis. Avoid it. There's nothing wrong about it. There can't be a unified bar on ideological basis. That will be a dangerous day for our country. I think there must be a bar, even if it is so divided on ideological, political basis, is a strength of the institution of the bar. But this division on ideological basis should not undermine the discipline of the Constitution, should not undermine the important factor that all of us ultimately have a bearing, the instrument. Therefore, I think while all these developments are taking place, the younger generation's involvement in matters such as this is a very inspiring factor for people like us. So when I came to the Supreme Court in the year 1979, I just look back in memory and see what is the court today. So there are a large number of influx of lawyers, and then lawyers who have come from a wide range of social, economic background. And every one of us who are thronging the High Court and Supreme Court are wishing to be part of part of building the nation, through the constitutional process. While you are able to, we're going to make a livelihood to the legal profession, I think that every case which comes to the court, if you're acting responsibly, I think responsibility is a very important factor. While you're talking about accountability of the judiciary, we cannot forget the responsibility of the legal profession. Responsibility in every minute of what you're doing as a legal profession. So if you're acting responsibly, I understand that every case you bring to the court is a case which reflects the social issues which need the highest level of resolution. Therefore, we reflect as social engineers, we reflect the needs and aspirations of the people. But we forget that, and we look at a profession as only, let's say, a commercial proposition. We look at it only a livelihood or a livelihood earning proposition. We look at it only again as a part of, let's say, a particular political party ideological orientation, then we are entirely wrong. I say yes, how to manage, to harmonize, how to fuse all these conflicting elements, I think is the genius of the bar. And how do you do that? I think therefore, I think it's important that those of us in the higher echelons of the bar, whether in terms of the, I think it's also important that the quantum of earning of the profession, I think, should hardly be a criteria. Should hardly be a criteria for the quantity, the quality of contribution one is making to the institution. For judges, and this perception among the younger generation that the sooner we reach the pinnacle of the higher echelons of earning, I think the sooner you drop that idea, it's better for the institution of the bar. So what is important for you is not that how many crores of rupees you earn in a year. What's important is how many crores of people in distress, in need of social justice, in need of justice administration, how many crores of people have been able to really go to rescue here, I think must be your mandate. I understand. I came to the bar with that understanding. I continue to practice that understanding, and I'm sure that we can, multiply so many examples of the great leaders of a bar in any part of a country, and even whether before independence or after. And that will take a very long time to read their history and find out how they contributed. I think probably we should devote one full day to understanding the great contributions made by lawyers of independence, lawyers of vision, and lawyers who thought that their role is not merely a monetary proposition. I was reading a book on three or four lawyers who made a world of difference in the U.S. constitutional history. But the author who was writing about that book says, for instance, the laissez-faire principle in the U.S. Constitution is something which is an integral part of U.S. Constitution. But how did it happen? It's because of the lawyers who continuously, persevered the courts that freedom, liberty, I think, is the bedrock of any constitutional principle, any constitutional framework. And therefore, today, when you talk of rule of law, what are we talking about? We're talking about institutions which are to be, manned by certainly persons who are to come from diverse backgrounds and will still belong to ideological, political, social orientation of diverse, backgrounds. Even then, we expect institutions will have certain integrity, institutions will have certain universal functional approaches. Is that perception, true? Or we are building on an illusory mirage? Somebody has studied about in the context of economics and demand and supply and some economic principle that a civil servant who occupies a position as a civil servant is not certainly a human being without needs and wants. He's not certainly a person who will keep away all those aspects of his mind and become an automatic machine to do what the civil service calls him to do. I think the same yardstick applies to judges. And it all the more applies to judges. Judges are not merely to execute a law. They have to declare the law. They have to create the law. Create a law in so many ways in contemporary circumstances. All those myths about that the judges only declare law is a dead proposition. The judges are active participants in creating, enlivening, and making the constitution work and function. And therefore, if we need to have that kind of a function to continue, and then where will they come from? If they come from the bar, and what are we going to do? And what are our commitments? If our commitments are very clear, that regardless of, and because of the diversities in our country, and we owe a great amount of loyalty to diversities to be preserved and protected. We owe a great amount of perseverance to ensure these diversities do not break or divide our country. And therefore, it of a rule of law, it is not really some Article 14 discrimination, equality, etc. It goes very deeper. I understand rule of law today means a constitution functioning without any disruption, without being distorted from within or without. And therefore, there are so many components involved in this. The role of the bar will have to be therefore perceived from this wide range of components and the dimensions. And let us not talk about it from any narrow sectarian angle. And let us not really criticize one particular generation of judges or a set of the bar who have taken upon themselves to ensure that they are the champions of causes of public importance. That's I think a very small story. There will always be a section of the bar. There will always be a section among judges who probably will be different from others. And because they're different from others, I think they're part of the diversity. And I think it's therefore important for the bar and the institution of justice to comprehend these diverse aspects and dimensions and ensure that rule of law in its very most comprehensive sense and understanding is this practice promoted and propagated. And that's how I look at the role of the bar and the independent judiciary. But therefore, today, when the entire world is now ruled by constitutional ideas. And can we, one last proposition, and I would probably conclude because the time is too short. Can we tell to each one of us today that we can forsake the constitution? Can any country today can say, I would probably like to live without a constitution. We can manage our lives without a constitution. I don't think today any part of the world, any part of the world, including communist China. You go inside a communist China, probably people ask for liberty and freedom, right? Therefore, we are wedded to the idea of a constitution, and wedded to the idea of a constitution means wedded to independence of institutions, and in what manner wedded to promotion, protection of diversity of the country. And what does it mean? It means that within this diversity, equality of all sections of people, and more particularly women and children, and more particularly the deprived sections of the community. Therefore, the role of the bar, as long as you understand that is to advance all this aspiration, then I'm sure, and I'm sure that many of those fringe issues about the conflict between the bar and the bench will all dissolve. And while somebody will be interested in dealing with the fringe issues, let them do that. I don't think we should be distracted our attention from that. They're all fringe issues. But the most important issue is how do we contribute to the maintenance of rule of law through constitutional discipline, through constitutional abiding. I think therefore we have many speakers to follow me, and I would probably go on. I just want to read a story, recollect a story before the Government of India Act 1935 came. At Roma, there was this writer, an Urdu writer, who wrote about somebody, a rickshaw puller, talking about 1935 Act as a new constitution, Naya Kanun for India. So he went out in the streets and said, Naya Kanun, and things like that. And the policeman thought he's mad and then pulled him inside and arrested him and put him inside the prison. The story goes like this. This man tells the policeman, look here, Naya Kanun, independence, liberty, freedom. They said, what Naya Kanun are you talking about? And arrested him and sent him to jail. The story says that the idea about a constitution, even though it was way back in 1935 and did not percolate deep into the minds of the people, but if you look at how from 1950 onwards, who went to the court? Who went to the Supreme Court? The most common man, whether it is in the case of, look at any one of the cases in the 1950s. The most ordinary people went to the court. And therefore, today also the most ordinary people come to the court. And that is a great promise of the independence of our institution. And that's a great promise of the role of the bar. And I think as long as the promise is kept, I think our institution, the Indian Supreme Court and the High Courts and all of the courts, I'm not getting into the details of the prevailing corruption, the subordinate court, and what should happen, etc. There are a lot of things happening. And most importantly, as long as we keep on debating them, and ensure that there is transparency in our debate, and the transparency also reaches the last human being in our country. While I was traveling from a couple of years ago from Long Island to New York to catch a flight, the cab driver engaged me in a conversation. He asked me, sir, what are you doing? I told him I'm a practicing lawyer in Supreme Court of India. Then he said, oh, that's great. But you know, our Supreme Court, US Supreme Court in Brown versus Board of Education did a great wrong. I sat back in my car and said, what is this? A cab driver knows so much about Brown versus Board of Education and the desegregation issues. How I wish every cab driver in our country, every auto driver in our country, every agriculture in our country, the last human being in our country, if only they understand Constitution is with them, Constitution is meant for them, and we have an institution called the bar with them. I think that will be a day when we would have probably liberated any number of people in our country from the yoke of unfreedom. So I thank you for the invitation. I would like to listen to the rest of my other colleagues who probably will have more and better important things to say than me. Thank you.
Thank you, sir. Thanks a lot for your elaborate knowledge and information on the independence of judiciary and role of bar. Sir, to you and all the viewers, I'd like to inform that under the banner of Delhi Advocate Group, started a signature campaign last night at 10:30 p.m. in support of protecting the independence of the judiciary especially the Honorable Supreme Court, and against constant interference in its working and functions by certain persons repeatedly, we have so far received more than 600 signatures from the advocates, including some prominent persons' names. I'll just name them, few of them only. Shri Abhijit, Honorary Secretary, Delhi High Court Bar Association. Shri Rajesh Teku, Senior Advocate, former Chairperson Bar Council of Delhi and former President Delhi High Court Bar Association. Shri Dinesh Agnani, Senior Advocate, is our guest also. Shri N Verma, Senior Advocate. Shri YP Singh, Chairperson Coordination Committee, Delhi District Courts. Shri V. Sekhar, Senior Advocate, our guest here. Supreme Court and former Vice President SCBA. So, friends, just to inform you that almost, sir, we around 600 advocates. So just after this, now I would like to invite Mr. V. Shekharji, Senior Advocate and former Vice President SCBA. Again, sir, a small note on, I sorry, you don't need all this, but still I am. After enrollment with the Bar Council of Delhi, he started practicing law in the year 1980 and has been continuously practicing law in Supreme Court of India. Since then, Shekharji was designated as senior advocate in the year 2006. He was appointed as a senior counsel for the Government of India in the Supreme Court in the year 2006. He was also the country councillor representing India in Law Asia, which has its headquarters in Sydney, Australia. He is also member of International Bar Association, London, INSOL, American Bar Association, Bar Association of India. He was one of the vice president of our Bar Association of India during 2016 to 2018. Sir, I welcome you on the virtual dais. Please, it's all yours now.
Thank you, Arunima. Good evening, friends. My respected senior colleague R. Venkataramani sir, with whom I had an occasion to do a lot of matters together, either on the same side or on the other side. And my friend from the other bar, including I could see Mr. Sharma, Mr. Dinesh Agnani, Mr. Vivek Reddi, Mr. Vivek Sood, then Mr. Ajit Singh, with whom I had an occasion to work in Jharkhand in some of the matters I remember, if I'm not mistaken. Anyway, much has been said by my previous speaker, Mr. Venkataramani, and he was probably concentrating only on the independence of judiciary. I know that is the topic, but I want to do a little transgression, and I'm not really going to talk on the independence of judiciary. I'm going to talk on the judicial independence. When I say judicial independence, how it is different from independence of judiciary, let me try to tell out some example, and probably my speech, which I'm going to do in the next 3 to 4 minutes, because I know already the allotted time for me is only 5 minutes. Let me try to complete as quickly as possible in the given time. As I was telling you, I see this topic as judicial independence, which is something different from independence of judiciary. What does that mean? I say that when a judge is sitting in his chair, has he got any pressure from any outside source, or is there any pressure from anywhere which restrains him from exercising his mind independently? That is how I look at this topic today. In fact, we have been seeing in the last so many days that there have been always external sources which has sometimes been acting as a pressure group for the judges to adjudicate the matter independently. It's very unfortunate this has been happening. In fact, I've been part of some of the litigation either as a counsel defending, because I always believe in one thing. In this country, the justice must reach the last man. It should not reach only the affluent. The justice delivery system is not meant only for the person who is on the top echelon of the society. It should also reach. So that is why I said, and we have been seeing in the last 1 month, let me not go as early as 1950 and other thing, because we know what happened during emergency, post-emergency, pre-emergency. I don't want to get into all those things. But my submission for all of you would be, are the judges independent in judging a matter? Are they influenced? Yes. Now let me tell you the first example. It has happened. Number of time it has happened to me. Number of time it must have happened to you also. And repeatedly, in a very sensational matters, whenever it comes to the court, we have a lot of respect for the press. We don't say anything. It has in fact been the torchbearer of many of our rights. It has been taking up the right with the right people. But of late, I have found that sometimes the press has been acting irresponsible, and sometimes the press has been conducting a parallel proceeding, which unfortunately greatly influenced, because I had an occasion to talk not one number of times to the judge, and they have been complaining that, sir, whenever we were about to hear a bail application of a very important personality, and nobody knows whether the gentleman is actually involved or he is not involved, that is for a matter of trial. But there will be pages of... Hello? 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 Hello?
So we can hear you.
We are listening, sir. We are listening.
Oh,
Please.
yes. Yes. So the judge in a private conversation has told me that there is a lot of pressure, because in the morning newspaper there has been a writing about that particular case, and unfortunately the judge, fearing any adverse report the next day, is either not able to decide, or in fact he sometimes passes the order to the lobby. This, unfortunately, I say, is not done. And we have also seen that sometimes, either in the social media group or in fact in TV channel, there has been a discussion, there has been a sweeping statement made by some of the social activists, or even by some of our lawyers who don't believe in a particular thing being dealt in a particular manner. And then they get away with it also. And recently we have seen the tussle which has been going on. See, these are all very, very sorry to say that unfortunately 20 years back we never experienced this. I have been in this bar for the last 40 years. I in fact know there has been a deterioration. I must only say that the judges must be allowed to independently adjudicate the matter and not be put under any pressure. This has never happened in the past, but it is only in the last around 10, 12 years things have been happening. Why it is happening? We must, in fact, I remember once I was arguing a matter in the Supreme Court, and I told the judge about this. He said, why don't you go and complain to the press council? We did do that. Complained to the press council, but the whole thing was then handled in a very routine fashion. But unfortunately, our client also lost interest and he did not pursue the matter. So I'm only trying to say that yes, most of the judges are very independent, they are very fearless, they do pass orders as per the conscience, as per their requirement of law, after carefully studying the facts and evidence, etc. But I must say 20% of the time, something or the other happens that in fact restrains. So now the point is, what is the role of the lawyers or role of the bar in this whole process? See, what I feel is there has to be a continuous dialogue between the bar and the bench, either through conferences or through meetings. And in fact, I must say that of late, number of times there has been an interaction which has been happening as a consequence of, say, there has been a lot of judgments which have been coming where the judges doesn't get influenced or doesn't get swayed by any public opinion. So that's a good sign. So what I feel is that the time has come that a clear message has to go either from the bar or from the bench itself, as it has happened recently, that any fair criticism of a judgment, absolutely there is no difficulty. You can criticize it. But when the trial is going on or when the matter is being heard or adjudicated, probably, well, you can in fact mention that as a news, but your views are not solicited. It is unfortunately this has been going on, and this has in fact curtailed, and people don't get justice as a consequence of this conduct of some people. So my respectful submission to the entire member of the bar and also an appeal to everybody would be to somehow, as a guardian, we must in fact educate the people that these kind of, even amongst us there are some people who keep on just giving some kind of small snippets to the press, and they keep on publishing sort of things. But the point is, the time has come and the court is going to take a very serious view of all these things, and then you cannot be crying that you have a freedom of speech, you can do whatever you want, and then you cannot be stopped. I think that that kind of defense may not be available to you. So with this, I would like to wind up, because I was totally on a different track. I was not on an academic thing which Mr. Venkataramani has started with, probably because I thought that will be only a repetition on my part. So I thought I will try to speak on a different track, and that is what I probably, it is my personal view, and I think, let's see, it has come from the heart. So I leave it to the chairman of the organizing committee to hand over this thing to the next person. Thank you very much.
Thank you, sir. Thanks a lot. And it was really very informative, sir. In day-to-day life, we see all this. So thanks a lot, sir. Now, I'll invite Mr. Harshvir Pratap Sharma ji, Senior Advocate. Sir, you are logged in?
Yes, I'm there. Can you hear, madam?
Yes, sir. He has 23 years of practice at Supreme Court, successfully argued against decriminalization of Section 377 IPC in case of NAS Foundation, appeared in number of high-profile matters. So he is well known to the bar. So welcome and to this dais, and please speak some points on the present topic. Thank you.
First of all, I'm grateful that Mr. Venkataramani and Mr. V. Sekhar, our two learned seniors, are there, and other members of the bar are there. I have assisted Mr. V. Sekhar also, and I learned a lot also. He guided me also. Now the question is, what is the independence of the judiciary? When we talk of the judiciary, do we think that bar is different? When at one point of time we call the lawyers as the officers of the court, we talk as a whole, then judiciary includes bar also. Bar is not only the part of the judicial system, it is a communicating link with the public, because judges can't talk to the public. It has a system inherent in it to improve the working of the court, to guide the person about the independence of the judiciary, and also to take corrective measures. For example, whenever we see some of the cases, like Supreme Court Bar Association itself came as petitioner in some of the cases, whether it was handcuffing of a chief judicial magistrate of Gujarat or anything. So bar has played a role. Now what is the next role of bar? Bar is also a mother of future judges. The kind of the knowledge, the kind of courage. Ultimately, the bar is to be constituted by courage and character of the persons who are practicing law. If we do not have the courage and character, in that situation, we will be a big failure, and we will not be able to do any service neither to the society nor to the judiciary or nor to ourselves. Now, the requirement is, if a lawyer is well read, he will have his own voice. If the lawyer has done his research, he will have his own voice. If the lawyer is courageous and is well organized, he will have his own point, and he will not only get the recognition, he will communicate well before the with the court as well as outside the court with the public. So knowledge is one thing which brings a respect to a person. If the knowledge part is lacking, then the person will not be able to move apart. If we see right from the beginning, before independence, bar had the members like Mahatma Gandhi, bar had the members like many persons. A few days back, I was reading one example about the Mr. Bal Gangadhar after the conviction of Bal Gangadhar Tilak. One of the persons said, no, I am very much against the judge. Now the question is, are we targeting the image as a member of the bar of the judiciary? And our said no. The answer is only this much. The core question is, as on today in 21st century, how much we can contribute and what we have to contribute. Now the next question is, bar is a healer, bar is a doctor, bar has to do a lot of service to the mankind. Number of public interest litigations which we have seen, they are the creation of the persons who were trying to help out certain group of persons, certain needy persons who were not having the money to pay the court fees and necessary charges. On the other hand, we have seen the development of the law. That is only because of the bar. Judges will do a case when it comes before them. Without of their own, they will not do certain cases in which they have taken up the cases suo moto. Even otherwise, they appoint the amicus curiae. So ultimately, the question comes. The question is with the members of the bar, what do they want to contribute? And if they represent a strong bar, they will also be getting the respect from the society, and they will have their own status. Now, for example, I will say two things. I was doing a case and I was told by a very senior member of the bar who was also in politics, you don't have to do this case. It was outside court number 4 in the corridor. I said, sir, I will not be able to say no to the client. You can talk to my client, but I will not say. I took up the matter. I did that and I got it. After some time, that gentleman realized that I spoke to a person who was not amenable to my advice. So now coming back to the situation. Under the present setup, the things have changed. Unfortunately, we talk of the first limb of the democracy, second limb, third limb, but bar is never considered as one of the strongest limb of the democracy. We give more preference to the press than the bar. Our lawyers do not have the sufficient. Why the problem has come of independence of the judiciary and the bar? Because of a simple reason that the country has not taken the care of the members of the bar. For other professionals, they are organized sector, unorganized sector, they get number of facilities like the media persons, etc. But unfortunately, the members of the bar, they are badly ignored by the society. And if you ignore a healer of the society or a group of the society which is serving a lot big purpose of the society, then the society is bound to suffer. For examples, lawyer, nobody will give a house to a lawyer, nobody will think of marrying marrying a daughter with the lawyer. Reason being that there are two faces of the society. One, the why I'm talking, it has some connection. The lawyer community is not being treated with respect, but when the matter comes at the time of the need, the first choice is the lawyer. Now, if such a lawyer goes to the court, he will lose his courage. So ultimately, in society, for becoming, it is a triangle: public, bar, and independent judiciary and court. So ultimately, for the purpose of the development of the law, a proper lawyer having the respect is must. For that purpose, society must take care of this situation immediately whenever the situation comes. Number two, the development of the law part comes, development of the law takes place as long as there are sufficiently good lawyers are taking care. Number three, the judiciary and independence of the judiciary comes. The lawyers always try to stand up in two ways. One on the negative side, another on the positive side. There are handful number of a person who will always try to superimpose and they will try to put their view. Who will try to put their view? They will try to say that we have the mass following and we want to put this is the correct view, and they try to force that the entire thing should be engineered in a particular manner. They will try to say, and this I am telling from my own personal experience, because that some other time I will tell the reason. So when I was doing a case, I faced number of challenges, and for that time, the moment I won that case, number of offensive languages were coming. I filed a writ petition. I told to the Supreme Court that this is the greatest violation of Schedule 3 of the Constitution of India. Persons holding the post, constitutional post, are attacking the Supreme Court. The Supreme Court said that judgment is very much there, order is very much there. So now what I say, unless until we take corrective measures to oust the persons who are working against the interest of bar, against the interest of the independent judiciary, because we give membership of everyone, so there has to be a professional code of ethics, and the committee must look into that which member of the bar is overreaching and trying to overpower the system, and against such persons the corrective measures must be taken. Otherwise, the innocent bar members who are coming and working daily, they will get deprived, and some 5-10% persons, they overpower and they become the voice of the bar. So ultimately, now the real question starts from here. Which member of the bar, either an innocent, hard-working lawyer who has nothing to do, is the voice of the bar, or 5-10% persons who manage the media and who come and they tell that this is the bar, is it the bar? So ultimately now all persons have to constitute and decide what should be the role of such persons who want to become the voice of the bar. So this is the time when everybody has to stand up and think, if we are the member of such a bar, which is not an independent bar, there will not be independent judiciary. If the judiciary is this, then this is the Newton's third law. What you do, the action and reaction. So ultimately, this is the high time with which we must, just a minute. So ultimately, what I have to say, that independent, well-read, well-communicable lawyers with the bar, those who have the courage, not only towards the independent judicial system, but also with the ethical bar, because for a lawyer to have the professional ethics is must. And the first ethics of the lawyer is, and the first ethics of the lawyer is that he should be truthful, not to other one, but to himself also, as well as to the rule of law. Here with this I conclude. I am grateful for giving the time. Thank you.
Thank you, sir. Thank you for your inputs on the Constitution and independence of bar. Now I welcome Mr. Dinesh Agnani ji, Senior Advocate. Sir enrolled as an advocate in the year 1980 after completing his law from Government Law College, Mumbai. He has been standing counsel for MTNL, BSNL, GAIL, India Limited, and many more. He was designated as a senior advocate by Honorable High Court of Delhi in August 2011. Sir, we welcome you to speak on the topic, please.
You see, let me welcome all my friends, seniors, and colleagues. The topic is judicial independence and role of bar. I think bar of the role is very important for the judicial independence. If the bar is not strong, the judiciary will never be independent, because ultimately everybody comes from the bar to become a judge. So first thing is we should emphasize that the bar should be strong and independent. Thereafter only the judiciary will become independent, because the judges who will be there will be strong judges who can decide things without any pressure or anything. In today's time, you see, there have been steps when attempts have been made to undermine the authority of judiciary. And fortunately or unfortunately, the role of the bar has been very silent on this issue. The power is vested with the judicial organ to ensure dispensation of justice to every aggrieved person, and there may be occasions when it has to be exercised in extrajudicial powers. So when Justice Kannan was hauled up for contempt for being, in spite of being a judge, a constitutional appointment, the Supreme Court had to take this position to save the system. So there are occasions when the courts have to exercise extra powers, contempt powers, to preserve the independence of the judiciary. Every person who may be aggrieved by the judgment has legal remedies available, but that does not give him a license to start criticizing the judges even before a judgment comes. It would be worth mentioning that persons who are today challenging the constitutional validity of law of contempt had in the past initiated contempt proceedings of our own lawyers. When the lawyers went on strike, they initiated contempt proceedings against the Bar Association of Delhi for initiating contempt proceedings when the bar had proceeded on strike because for some genuine grievances. Keeping in view these facts, we believe that members who are trying to undermine the judiciary should be dealt not only sternly, but the bar should also take steps to ensure that they are removed from the bar so that they don't indulge in such activities in future. I feel that bar and officers of the court, being part of the justice administration system, should believe in rule of law and respect our judicial organ, and shall always strive to preserve the independence of judiciary as it is a basic structure of our constitution. The bar should play a very important role and ensure that as and when somebody tries to interfere in the independence of the judiciary, the bar should take up the role and try to protect the judges so that unnecessarily the judges are not put to embarrassing position. Therefore, my thing is that the bar role should be very strong so that the judiciary remains independent. Thank you.
Thank you, Agnani, sir. In such a short, you have explained it very well, nicely. Now, there is actually, Mr. Vikrant has to move. He is in some urgent meeting. So I have to break the protocol. So in this, I call upon Mr. Vikrant Yadav, who's the practicing advocate in Supreme Court of India and is the former Secretary, Supreme Court Bar Association. I welcome you, Vikrantji, to speak on the topic.
I thank the organizers of this webinar for inviting me as one of the speakers, and it was great hearing. It's always a pleasure hearing Mr. R. Venkataramani, Mr. V. Sekhar, Dr. H.P. Sharma ji, and today I heard Mr. Dinesh Agnani ji, senior advocate. I come straight away to the topic that the legislature and executive, we have seen in past that they have always been trying to take away the independence or the powers of our judiciary, and bar has always acted in a very responsible manner. We have seen that the judges are very lonely people. They normally don't go out in public. They can't address their issues and grievances in public. They cannot use public platforms for their grievances, and they can very easily be cornered under such circumstances. We have seen as a former secretary
Vijay, I'm so
for
sorry
two
to
terms.
interrupt you. Your camera is off, I think so. I'm so sorry to interrupt you.
Is it? Am I visible now? Am I visible now?
Yes,
Hello.
yes, yes, now, yes.
All right. I hope my voice was audible.
Yes, yes, sir. Really.
I quote an example. When I was secretary for 2 years, the two chief justices, Justice Deepak Mishra, fell to controversy when 4 judges went on media stating that they are not getting a good number of cases or important cases, even if and subsequently within fortnight. Judiciary has to be maintained. So we, as an executive, we went to Honorable the Chief Justice of India. We requested him that each and every court be assigned a particular category of cases, and that may be published on public platform. That may be on Supreme Court of India's website, and that is how it was overcome. Subsequently, in the second term, Justice Gogoi fell trap to some kind of a scandal. That was also investigated by 3 sitting judges, and that was also found to be incorrect. Now, of late, we can say, hello, am I visible now? Hello.
Vikrant, you're not visible, you're audible. But yes, yes, now it is okay.
Yeah, in recently we have seen there are particular hardly 4 or 5 people in the bar who are always criticizing every chief justice, almost every judge who is passing any kind of independent judgment. You can discuss about the judgment, but you cannot criticize a judge or try to bully him or try to pass some kind of a comment so that you may try to corner him. This has been happening recently, and we have seen, I have quoted just 2 examples. We have seen with the present chief also, we have seen with Honorable Mr. Justice Arun Mishra also. And these are the very same people who have the audacity to be called as heroes. And they are, to my understanding, they are basically blackmailers. And this has they have been doing this not today. They have been doing for over 2 decades. Like, for example, when Justice M.M. Punchi was the Chief Justice, he was also tried to be bullied. Then Justice A.M. Ahmedi, it happened the same way. With Justice K.N. Singh, it happened. With Justice Y.K. Sabharwal, it happened. It happened with Justice K.G. Balakrishnan. So there are a series of, and ultimately when the term of these judges gets over, then the issue also drops. We have never seen any controversy coming to some logical conclusion because everything was in air. And these are the same kind of people who says that there should be referendum on Kashmir. They remain the very same people remain silent when lakhs and lakhs of Hindus were shunted out of Jammu and Kashmir overnight, and they all kinds of atrocities were happened on them. They all remain silent. But at this point of time, they also say that there should be referendum by that Kashmir may be independent. So we have to understand these people. We have within us. We have to avoid that they should not come anywhere close, so that our independence of judiciary may come down. As far as bar association is concerned, it has a very important role, and we may have a political allegiance to any political party, but bar has to remain united for keeping the independence of judiciary alive. This is what all I have to say. Thank you very much.
Thank you, Vikrantji, and thank you for sharing your experiences with the bar. Now I invite Mr. Vivek Sood, Senior Advocate.
Thank you. Thank you very much.
Mr. Vivek Sood, Senior Advocate, has close to 3 decades of litigation experience in Delhi High Court and Supreme Court in diverse branches of law, such as economic and other criminal offences, business and corporate laws, constitutional law, arbitration and technology laws, etc. He has authored numerous pioneering books such as The Fundamental Rights to Internet, Cyber Law Simplified, Cyber Crimes, Electronic Evidence and Investigation, Legal Issues, and is currently writing on arbitration and insolvency laws. He frequently lectures on legal and constitutional issues on different platforms. Apart from the legal profession, he proactively exposes social causes such as rights of prisoners and promoting awareness related to DNA evidence. Sir, I welcome you to this virtual dais, and it's all for you to take.
Thank you. Thank you, first of all, for being very generous towards me. And it's a pleasure to be here on this platform and getting on with the topic. It's a very relevant subject today in our contemporary times, in the present times. The subject you have chosen is very contemporary, very relevant for every citizen, not only the bar and the judiciary. I will start by asking a question to myself as to what is the meaning of independent judiciary. An independent judiciary is a judiciary which follows the doctrine of separation of powers laid down in the Constitution of India. Meaning thereby, the judiciary must be independent of the government of the day. And that is what is meant by an independent judiciary. Now the question arises as to whether the judiciary today is independent or not. Now that's the question. That's the question for the forum today. In my view, the judiciary is very, very independent as of today also. There is no question of the judiciary being connected to the government or being dependent on the government or being pro-government as is alleged by certain people. And I will give you certain examples, to prove my point, to bring home the point that the judiciary is extremely independent today. Let's take the example of Shreya Singhal. Now, Shreya Singhal is a judgment of the Supreme Court where Section 66A of the Information Technology Act, which defined and punished internet abuse, was struck down by the Supreme Court as unconstitutional. It was held to be violative of Article 19(1)(a) that lays down the great freedom of speech and expression. Now, if the judiciary was not independent, why would the Supreme Court strike down 66A? This reflects, it brings home the point that the judiciary is independent. The second example, Section 45 of the Prevention of Money Laundering Act has been struck down by the Supreme Court. It was legislated by the government. It was legislated by the parliament. It was challenged before the Honorable Supreme Court, and the Honorable Supreme Court struck it down as unconstitutional for it being in violation of Article 21 of the Constitution. Now, yesterday, the Supreme Court has made a statement on the moratorium issue, moratorium of loans. Now, the Supreme Court has gone ahead and made a statement that the government should not hide behind the RBI. The government must take a stand under the Disaster Management Act, whether the moratorium should be continued or not, whether interest should be charged from citizens or not. If the judiciary was not independent, the Supreme Court would not have made such a statement against the government. So the judiciary is independent. Now, in arbitration law, now we keep talking about PMLA and IT Act. The other day I was reading a judgment, Palm Developments, where the Supreme Court has said that in arbitration matters, the government and the private entities are on par. They have to be treated equally. There cannot be any disparity between the government and a private litigant, an entity. If the Supreme Court was not independent, this statement would not have been made. This law would not have been laid down. So there are so many examples. The Supreme Court has gone ahead and decided against the government, decided against the laws made by the parliament. Therefore, the judiciary in our country is extremely independent. I have no doubt in saying that. Now coming to the role of the bar. The role of the bar is to be fearless. And the bar must stand for the rule of law. Now, in my submission, I will take a contrary view. I must say that the leaders of the bar have let down the bar during this pandemic. I'm not talking for myself. I'm a senior counsel. I've been doing 3 to 4 to 5 video hearings every week, and I'm comfortable in life. God has been very kind to me. As a senior counsel, I have no difficulty. I do all kinds of video hearings every day in the High Court, Supreme Court, and the courts below. But I feel for the youngsters of the bar. I feel for the base level lawyers who appear and who earn by the day, who earn by the week in Tisadari court, in the lower courts and other courts. The leaders have, in my view, let down the bar as a whole in this pandemic. You know, I can see that only not even 1% of the work is being done through video hearings. Now, what happens to the legal community? The government has not come to the rescue of the legal community. The judiciary has declared a shutdown, a lockdown of the courts because of the pandemic. And the leaders of the bar should have come out in the open to support the youngsters, to support the poorer members of the bar who live by the day, to have the courts open. Now, today I find that Delhi has opened up. You go to Delhi, the traffic in Delhi, everything has opened up. Every institution is working in full strength. The institutions are working. Why not the judiciary? So therefore, in my view, the bar, the leaders of the bar, they must play a much more proactive role than what they have played, So it's a learning curve. I'm sure the leaders will take a cue from what I'm saying. And I'm only reflecting the sentiments of the millions of lawyers, who practice in the district courts across the country. I'm not talking for myself, of course. Now, the role of the bar, there are other dimensions to the role of the bar as well. For example, I don't subscribe when the bar threatens the courts. Many a times I have seen, you go and argue a bail application in Saket court or the lower courts, and you are arguing the bail application, and you find the whole executive, the leadership on the other side, in the courtroom, opposing your bail application. So these are some practices which need some reform. When there's a litigation between X and Y, the bar should never take a position one way or the other. Secondly, I don't believe in strikes by the bar. Strikes by lawyers is the last thing that the bar should engage in. So, these are two things. And then using unparliamentary language. You may criticize the judges. Judges have no difficulty. You may criticize the judgments. There is no difficulty at all. It falls within the ambit of Article 19(1)(a), freedom of speech and expression. But using unparliamentary language, using threatening language, using abusive language to the court, to the judges, is not done. So, the role of the bar, we have to define the role of the bar. We have to redefine the role of the bar, and we have to learn with experience. And I'm sure the leaders of the bar will stand by the legal community at large in the times to come. It has been a difficult time for base level lawyers. I feel for them. And I hope the leaders of the bar are listening and they will take a more proactive view in favor of that base level legal community. Thank you very much.
Thank you, Sood sir. Thank you for your important insights on the independence of judiciary as well as the bar. Now, I invite Mr. Vivek Reddi, Senior Advocate. Mr. Reddi, a designated Senior Advocate of the High Court of Karnataka, having extensive practice in the High Court, commenced practice in the year 1995 in Supreme Court of India. Thereafter, has been practicing in the High Court of Karnataka. He was designated as Senior Advocate by the High Court of Karnataka in July 2014 at the age of 42. He is also a well-known and popular media panelist. So, welcome you, sir, on this virtual dais.
Thank you.
Yes, sir.
Thank you very much. Am I audible?
Yes, sir.
Yes, yes. Thank you very much to the illustrious speakers who have spoken till now and contributed and illuminated this subject. It is indeed a great thing that all of us are discussing this issue of national importance. In times of crisis, this is when we have to put our thoughts together. I think all the speakers have dwelled upon various aspects of this issue. I could just, if I could just add a little bit. First thing is, what I feel is that we have inherited a great country. And that's where it commences. When we got freedom, we started the nation rebuilding process. And as part of this process, we have crores and crores of people in poverty, and we have to move forward. So the nation is the foundation. Our judiciary is the pillar. And it is left to us as to how, whether we desecrate this pillar or whether we keep this pillar strong and high as a rock-like edifice for this country, which supports this nation, its constitution. That is what we are. That's the question today before us. And unfortunately, I see that of late there have been attempts to disparage this institution, to condemn this institution, and to bring it to disrepute. And this is what we are seeing now that is happening. Before we understand how we build this nation based on our constitutional values, I think a lot of stress needs to be made on the duties of a citizen. Unfortunately, in India today, we only talk about rights. Today, one of the biggest questions that is being raised in this contempt case that is now running before the Supreme Court is, this is a violation of the fundamental rights of speech and therefore scrap the Contempt of Courts Act. This is what is coming, voice coming from one quarter. Well, the biggest question today is also, apart from your right as the right of freedom of speech, what is your duty as a citizen? What is your duty as an advocate who is a member of this institution? And what is your duty to the nation? I think these questions somehow have skipped the narratives, have skipped the voices that are supposed to be, that are supposed to look into the subject holistically. Whenever there is a judgment against me, it is natural that I vent that fury and frustration. But is it the duty of a citizen to vent venom and hate against that judgment? No. You cannot have a malicious intent to vent venom and hate. That is a barrier, that is a limitation. If you cross that limitation, my question is, if you cross that limitation, you're getting back to the old jungle law, where you can say anything and get away. You simply can't do that. Second, as part of this duty, as an advocate, as a citizen, as a person belonging to the nation, is whether you can standardize the court, no. Whether you can politicize the judgment, whether you can add political color to it, no. But unfortunately, this is being done. And as custodians of this institution today, we need to ask whether we will permit this. One of the senior advocates beautifully spelled out that, look here, who are the voices of the bar today? The voices of the bar are all of us. It is not just one person. who wants to disparage or insult an institution. No, we are all the voices of the bar. A single person cannot claim a monopoly over it. But unfortunately, political color is being added. You know, when we were children, a rich man used to come with his child used to come. He used to bring his wickets, he used to bring his cricket gear, everything. If somebody got him out, you know, he was declared bold, he would say, if you declare me bold, I will take my wickets and go. Is this the mentality? If I don't win the case, then the institution is to be rubbished, is to be shamed. Well, that is the mentality we are seeing. It is my way or your no other way. Either you accept my way or you cannot do it. So is this the duty? This is what I'm asking. Is this the duty of a responsible advocate to take this path and say it is my way or your way? If you don't come through my way, then I will insult you. What are you trying to threaten? So this is where I see there is a very cockeyed view. There is a very, dubious view about what applies to me and what should apply to the institution. And this has to change. And we as a bar, believe me, this is very threatening. And we as a bar must stand up in unison and condemn this. There is one more issue, very interesting. Some of these lawyers today have raised a letter and said, two aspects in this letter, very interesting aspects. They have said letter to the Supreme Court of India, judges of the Supreme Court of India, and letters to the people of India. Very interesting. These 20 or 30 advocates suddenly have remembered the people of India and have said, please don't do this. Please don't commit him for contempt. Reverse your order of guilt. Well, I ask these persons who today are seeking the assistance of the people of India to address the Supreme Court. I ask these persons, where had the people of India gone when you were advocating the cause of Kashmir Azadi? Where had the people of India gone? You never remembered them, but today you want to remember them. And we want to ask them, when anti-national slogans were raised, they lent a pillar of support. And today, that time they never thought about the people of India. Today they have come to the rescue, to the running to the arms of the people of India. Why should the people of India support you? Why don't you go and ask the causes you espoused? So this is where we find the approach is dubious. The approach is diabolical. And it cannot be countenanced at all. So there are limits. What all I'm saying is, when you are looking at an institution like the judiciary, you're talking about its independence, then you have lots of duties. You will have to adhere to those duties. The other, we go to Article 51A of the Constitution. Article 51AC says, to uphold and protect the unity and integrity of India. This is one of the fundamental duties. Well, today you're saying, I'm a honest man. It is my honor. I want to ensure that, I save this country from destruction of democracy. All high words. Beautiful. Well, sir, you wanted to destroy the nation. You wanted to say, let there be Azadi. And today you say, you suddenly thought about, put a mirror on yourself, no? Why don't you put a mirror on yourself and look at yourself? There are high words like contempt of my conscience, dear friends. We should look at these words. Contempt of my conscience. Well, you forgot about contempt against the nation. A nation which gave you life, which gave your family life, which gave your father as a greatest advocate of this nation. A nation which gave you everything. And you're not looking back. You have no two thoughts when you commit this contempt of the nation. How sad. How sad. Isn't this duplicitous? Isn't this double-minded, double-tongued? Therefore, Aristotle used to say, look here, whenever a man stands up to speak on any issue, Aristotle says in his book on rhetoric, he says, look at the character of the man. Today, people are influenced by high words. People are not influenced by great rhetoric. No. they will say, what is the character of this man? What is he preaching? Is he preaching? Is he following what he is preaching? And unfortunately, we find a tremendous gap between what is being preached to this nation by these persons, and particularly by the contemnor, and what is being followed by him. We find that huge hypocrisy there. And that is not pardonable at all. Upon this hypocrisy, there are various duties, my friends, my dear friends. We discuss these duties. We discuss this diabolical stance. But upon this, what makes it worse? And that is where we have to be sensitized, or we have to be aware, or we have to light the candle of caution there. The last stage that it has reached is quoting Mahatma Gandhi, quoting, trying to act as a hero. I think these issues will have to change. I feel that the bar, my time is up. I feel that the bar must come out strongly and take up these issues and fight these issues. Therefore, I request that all this playing to history drama, all this Gandhi drama, let's stop all these things, please. The independence of judiciary is at most. You are talking about destruction of democracy. Well, you have destroyed this institution. Thank you very much.
Thank you, sir. Thank you for your enlightening words. And more so, it can be said, a bad workman always blames his tool. Now I welcome Mr. Ajit Kumar, Senior Advocate and former Advocate General, Jharkhand. He was Chairman of State Bar Council from 2017 to January 2020. And he was Additional Advocate General of State of Jharkhand from 2011 to 2017. Welcome, Ajit, sir. Platform is all yours.
I'm thankful to Delhi Advocate Group. But before I start, I want to complain the organizers, because hearing Venkataramani Sahab and all seniors, I think they would have spoken at last and we would have spoken before, because most of the issues, most of the points which we now take up, it has been covered. So he would have analyzed better. That is the correct protocol. Senior goes at the last and juniors come first.
We are sorry to that, sir.
Yes, indeed, today's topic is very, very important. In view of the recent developments which have taken place, the role of judiciary is being discussed, and what role we lawyers, the bar, has to play. That is also a matter of discussion today. Mr. V. Sekhar Sahab, who was here, he rightly told that few years back, these issues were not there. The way lawyers knew they are supposed to work in the court, they used to expect the judges to behave with them in a proper fashion. That used to happen. How things are changing, yes, it is a burning topic today, and we are here to discuss how things have developed in Supreme Court after 1998 and thereafter. When this PIL came, yes, this PIL gave lots to the society, lots to the bar, but we have also changed a lot, and we have also reacted to the activism which is coming from the court side, and we are also being very much active, but sometimes we are being destructive also. This is absolutely incorrect. I would say that if we see the provisions of the contempt of court, that topic is at least left for me, so I will take up that. If we go by the provisions of the Contempt of Courts Act, Section 2C defines the criminal contempt. And see, for you all and for myself, I shall be reading it, how beautifully the words are used and how this law has been framed. Just see, it reads, criminal contempt means the publication, within bracket, whether by words, spoken or written, or by signs, or by visible representation or otherwise, of any matter, or the doing of any other act whatsoever which scandalizes or tends to scandalize or lowers or tends to lower the authority of any court, then or prejudices or interferes or tends to interfere with the due course of any judicial proceeding, or interferes or tends to interfere with or obstructs or tends to obstruct the administration of justice in any other manner. Other provisions up to section 7, if we see what shall not be a contempt or what shall not be a criminal contempt, we can understand easily. But I want to just say that the limits which we have to maintain and what shall be treated to be a criminal contempt or a civil contempt, the contours, the line is already drawn, and we have to understand that. According to me, recently, what has happened, I can explain like this. If an order is passed by the court, we criticize it on merits. If we speak about that judgment or order, it is perfectly all right. We can criticize it on merits. But if that order, which is not in fact of a judge in particular, if that order we criticize as if it is the property of a particular judge, and then we attach that order with that particular judge and we criticize the judge itself by saying that the judgment or order is the outcome of corruption, then we will be crossing our limits. Judge has got a different character, different identity. He's a person, no doubt. The person sits as a judge, but the person, while sitting as a judge, changes his identity and he becomes a judge of the court, and we have to essentially respect a judge. If we criticize a person, do not attach that person with the institution of judiciary and say something, it is all fine. What I find is that the things are being mixed up. I'm not naming the lawyer, but the way after saying lots, after writing lots, if he says, no, I had some different intention, I want to change the institution, I want to give some impact to the institution itself, according to me, his perception is absolutely incorrect. If a person is moving somewhere, if I address him by name, I can understand, I can criticize him also, I can speak against him also. But if I address him as a judge of a court or Supreme Court, I shall be maligning our institution itself. According to me, this is not permissible. There are lots of things which can be spoken out at this point of time. We have our own limitations, and we have to essentially respect the institution because we are not only the officers of the court, but the bar is supposed to be the second wheel of the same cart. If judiciary, if the prestige of judiciary is high, if the respect of judiciary is proper, then only we are supposed to be respected, and we are respected. So in my personal view also, we have to maintain some restraints. We have to understand our own line and limits, and we should not cross our limits. We have to essentially respect our institution, and scandalizing the judiciary or persons as judges of the court. According to me, it is unfair, improper. That should not be done. I think my time is over, so I'm concluding here. Thank you all.
Thank you, Ajit sir. And very nicely put up the today's topic. Now, I invite Mr. N Verma, advocate practicing in High Court as well as Central Administrative Tribunal. Verma ji, welcome to the dais, and please put your topic.
Before I come to the topic, I compliment and appreciate the efforts of Delhi Advocates Group, its convener Mr. Ripudaman, Bhardwaj ji, Neeraj ji, for just organizing this kind of webinar in this scenario. Because in the absence of this kind of webinar, what was happening, there was one-sided narrative being created and by a handful of people, and they were creating or they were portraying the scenario as if heaven is going to fall if a particular lawyer is given punishment for which he has already been convicted, and there are scores of the people. There are retired judges. There are senior lawyers. Then there are there is international media, national media, who are supposedly called as liberals, so-called intellectuals. All these peoples have ganged up, and they are and believe me, they are not much larger in number. They are handful of the people, but they have ganged up, and they have been writing articles, they have been tweeting, and they are also allowing the interference of international media, then Human Rights Association of International Media, wherein they are just pleading, no, this advocate this advocate should not be punished. They are saying you repeal the contempt of criminal contempt law, and that is the scenario. And they are handful in number, but they are a pampered lot. They comprise of a particular lobby. They are not much bigger in number, but they have ganged up in such a manner, and they have got so much of support from leftist liberals and so-called secular group, that they feel pampered. They believe that they are the sole custodians of the Constitution, and they have taken upon themselves the role of interpreting the law. They dictate you. Either you have to act on my dotted lines, otherwise I will defame you, I will vilify you, I will demonize you. They have been doing it with executive. They have been doing it with many persons in the media who are not to their liking. I mean, they don't spare even our prime minister and home minister. They have been after him since 2002, and whosoever would take a contrarian view, whosoever would take an alternate view, all of them would gang up and they would vilify such person, and that is what is happening in present context also. Coming to the topic of this independence of democracy and role of the bar, there is no denying the fact that independence of judiciary is the essence for the defense of the democracy, and for independence of judiciary is very, very important for protecting fundamental rights given by our constitution. It is very, very important for delivering justice to common masses. And so far as role of the bar is to help judiciary fulfill all these laudable objectives, but at the same time They have to be fearless, they have to be bold, and they have to show their independent mind to just say that yes, my lords, you are going wrong in this particular manner. And but their role is to indulge in healthy criticism, but their role is not to scare and bully the judges and convey the message that if you don't if you don't act as per my wishes, then I am going to defame you, I am going to criticize you, I am going to just vilify you, and that is what is happening in the present context. These are the people. I mean, they would they act as holier than thou attitude, and they have sort of they feel that I'm born with a silver spoon in my mouth, and I should be given all the privilege, and only I'm entitled to freedom of expression and nobody else. And if somebody and I have got unfettered right of freedom of expression, I can defame anybody, I can say anything to anybody, and nobody can convict me, nobody can punish me. And so far as talking about contemporary issue, I mean, somebody is saying that you are riding a bicycle of 50 lakh belonging to a particular party, and you are saying that you are indulging in healthy criticism. What do you mean by saying that you are riding, you are alleging Chief Justice of India of riding expensive bicycle of 50 lakh rupees belonging to a particular party, and you are saying that you are indulging in healthy criticism? Are you not casting aspersion on the integrity of Chief Justice of India? Can't after on the verge of the retirement, does he have no can't he have 50 lakh of rupees to fulfill the dream of riding a particular bicycle? And what do you mean by saying that he's riding bicycle of 50 lakh? You are casting aspersion on the integrity of the Chief Justice of India by saying that he was riding on the bicycle belonging to a particular political party. You are saying that the Chief of Justice of India is not independent, is hand in glove with a particular party. What is this? Then you are also saying something which is you are saying that last 4 chief justices, they were responsible for destruction of democracy. I mean, what do you mean to say? I mean, Supreme Court is the last hope of common masses of the country. When people are tired of all their efforts and they don't have any other means, then they look up to Supreme Court for getting the justice. Talking about the contemporary issue, I mean, everybody knows what was happening in case of Sushant Singh Rajput case. Nobody knows. Even I don't know whether Sushant Singh Rajput was murdered or he had committed suicide. But most of the people had this kind of in their mind that he was murdered, and common masses, they felt that there should be investigation by CBI, and a particular state government was coming in the way, and that was the time common masses of the people, they were looking up to Supreme Court, and Supreme Court made their expectation. They have handed over the investigation to CBI. It has happened in many cases. Supreme Court, on more than many occasions, they have met the aspiration of the common masses, and you can't vilify them. And it that a particular lawyer or only a particular set of lawyers are entitled to differential treatment? If a particular lawyer is convicted, then whole gang up, a particular gang is ganged up and start criticizing the court. then they say no, I mean that was wrong conviction. After conviction, then they are saying that there can't be there can't be sentencing order. They are saying that no, I mean it should be heard by it should be heard by larger bench in open court, and that too after pandemic is over. What is this? I mean, on daily basis, thousands of cases, people are convicted, and after that, there is sentencing order passed. And in this particular case, they are saying no, there can't be a sentencing order. It has to be deferred only after it is heard by larger bench, and that too in open court after pandemic is over. Only then this person can be punished. And in many cases during last 3 years, there were two. I would like to name two lawyers. One was Mohit Chaudhary, and second was Mr. Matthew Nedumpara. I mean, all these people, they were just they had made far less. Their charge against them was of much lesser degree, but still they were, and still after, and despite their apology, they were punished. I'm not passing any comment whether Supreme Court was right or wrong. Once Supreme Court has given its order in a particular case, then we don't have any choice but to accept it. But I'm saying, when these two people were punished despite their apology, why in this particular case the lobby is saying no, he can't be punished? No, even if he doesn't apologize, even then nothing should happen. He's a Gandhi. He's like Nelson Mandela. I mean, what is this kind of attitude? I mean, there can't be differential treatment, and that is where the bar has to intervene. Nobody should be allowed to have a differential treatment. Nobody should be given the impression that the person is born with silver a spoon in his mouth. The person has to be told, you according to Article 14 of the Constitution, everybody is equal before the law. And if two lawyers have been punished for far lesser charges, and if they can be convicted despite apology, why somebody should say no, despite conviction there should not be sentencing, and despite no apology, even then the matter should be ended there only? I mean, why we are doing like this? This is and in this particular case, the role of the bar is also very important. They must say no law, no lawyers can't, lawyers are at parity. Somebody with far lesser degree of crime, if they can be punished, then other person who has been convicted for very serious charges, the person must be convicted.
Because of some short of time, we are running short of time. So
yes. So
I'm so sorry to interrupt.
My only submission is because this particular topic is had many aspects. I only touched upon one particular aspect, that is differential treatment, and my predecessors have already touched upon many aspects, and I hope other speakers following me, they will touch upon other aspects. Thank you to everybody.
Thank you, Verma-ji. Thank you. So putting it so straight. Now I call upon Mr. Ajay Singh, Advocate on Record, Supreme Court of India, to please address. Welcome, Ajay.
Particularly Neeraj ji, Ripudaman ji, Ajay Iqbal ji, those who have created this web platform for discussing each and every issue. And I think regularly you people are organized these same webinars. It is my honor and privilege to participate in this webinar on the topic of judicial independence and role of bar. Friends, it is very interesting now, even after 14th of August 2020. Actually, after this judgment of conviction has came out, there are so many hue and cry regarding sentencing and something. But we all know that sentence is a part of conviction order and sentencing order are not different. It's a part of the only one set of judgment. Friends, on this topic, after hearing the deliberations of all the so many senior advocates, and including N Verma ji, nothing left to speak, but I'm adding some word. Friends, independence of judiciary and legal profession is both the fundamental pillars of the administration of justice. The very fundamental foundation of judiciary is trust and confidence of the public. Only and only trust and confidence of the public is protecting the democracy in the judiciary, nothing else. And why? Because in a democratic set of governance, what happened? Legislature make the law, executive implement the law. Then people are always biased. There is something in the mind of people that legislated the law. That means he is a party. Executive implementing the law. That means he is also a party. But they have faith on judiciary because here they found the third person who is reviewing, who has authority to review the law. That's good for public, that's bad for public, that is against the constitutional norms, and so many things. This is the very reason that the concept of contempt has been initiated. Because this is the third one. The judicial part of the governance is not involved in the governance, only reviewing. And if a democratic society lost the confidence in the judicial system, then democracy has to go. Then democracy will not survive for long. Hence, being a part of the justice delivery system, bar has an important role. Independence of judiciary means independence of bar also. Except some misuse of the statement, bar should always refrain themselves from any act or omission which even remotely affect the reputation of judiciary. Bar and its member should always be vigilant and avoid any statement or any kind of post on social media which tends to shake the public confidence in judicial independence. It should not touch even the statement or the post on social media. If it scandalizes or tends to lower the dignity of it, come under purview of the criminal contempt. These statement cannot and should not be protected under Article 19(1)(a), because if you are talking about Article 19(1)(a), then you have to also consider Article 19(2). Friends, a lawyer has to maintain a balance in between opposing notion of individual liberty and institutional interest both. Here, after 14/8/2020, we are realizing that the individual liberty, in the name of the protecting of the individual liberty, a set of persons of this country are trying to damage the institutional reputation, institutional interest. Is it not the contempt? If institutional doesn't survive, then where would you go? Friends, it's the era of institutional decay. One of the sociologists written in 1960 that post 2020, 2000, the era of institutional decay would start. What happened? A set of people is questioning the all established institutions. They are creating doubt in the mind of citizen that this, and this institution is not working. Their target is to remove or diminish the interest of the institution. Friends, suppose a member of the bar use a sentence regarding that some number of CGI has failed to protect democracy. What would be the impact on the citizen of this country? A country like India, where the people had utmost faith and respect on the judiciary, and an active member of the bar is speaking like this, then what happened? Who would convince the citizen? Who would protect the respect of the judiciary? If a member of bar is doing so, it is very serious for any institution. No institution can survive with such kind of people. Nowadays, we are very frequently hearing that in last 6 years, democracy has gone. Supreme Court has failed to protect the interest of the country. What happened in 6 years? We have to find out. And I agree. I hope that you all would be agree that no corruption charges in last 6 years. Nothing has been changed in the Constitution of India. Not a single person cast on the government, even though democracy is under threat. And why they are questioning the last 4 chief justices? Because I know the answer. One of the chief justices asked in the open court that Mr. So-and-so, what is your homework before filing this PIL? What kind of mechanism you adopted before filing this PIL? He was keep mum. He had no answer. He was not satisfied the court. Thereafter, that chief justice was bad. The second chief justice, his successor, asked the same thing. Mr. So-and-so, what is the homework behind this PIL? What kind of set of people you have any data analysis? You did something? No. Then he is also against them. Thereafter, the third chief justice when came, what he did? He settled one of the most sensitive case of this country. This is the wrong committed by that chief justice. And the sitting chief justice, he also committed so many wrongs because he did not interfere with the Kashmir issue. Though it's a national importance, issue of national importance. These are the things, friend, which has been done. And now they are asking for showing the statementship by the Supreme Court.
Ajay ji, slightly sorry to disturb, but small thoda time
Just I'm concluding in 2 minutes. Only within 2 minutes. Friends, when I joined the profession, I just entered in the cafeteria of the Supreme Court. I just directly came from my village and joined the Supreme Court. I just called one of the waiter in very loud sound. My tone or tenor was not good. Mr. Now he is no more. Andharu Jina was sitting adjacent to my chair. He came on my table and advised me, friend, you are sitting in the Supreme Court. You are not in some other court. Why I am putting this example here? Because whatever mistakes committed by us right now and whatever good things done by us would have directly impact upon our next generation. Hence, we should avoid anything, any statement, any post on the social media which is sufficient to scandalize the judicial system. Thank you, everyone.
Thank you, Ajay. Thanks for your insights. Now I welcome Mr. Balendu Sekhar, who's advocate in Supreme Court of India and National Green Tribunal. Welcome, Balendu. Please, it's all yours now.
Good evening to everyone. For me, indeed, it is a great pleasure and privilege as well to be a part of this August, the team of this speaker, and the topic which is the judicial dependence and role of the bar. We all must keep one thing in mind, that advocate acts as a barrier between law and knowledge. We are the one who create perception. And if we as a lawyer start downgrading, start daunting the perception of the very same institution, then what kind of message, what kind of image public will build about the institution? Now we all, as we all know, that today we are discussing these topics in context with the particular incident. We all know that the way in which all these issues have been built or have been created, it clearly demonstrates that the manner and the way in which the individual person has taken the Honorable Supreme Court as granted, this should not be accepted at all costs. Because when we see the Constitution of India, Article 19 also talks about decency and morality. Whatever you say, and that too as an advocate, you must keep that two very vital aspect in mind. And when at the same time, when you will see the content which he posted on his Twitter, which as we all know that his Twitter is being followed more than several lakhs people. And deliberately, if he makes a kind of statement that for the last 6 years, democracy has been destroyed, all last 4 CGI has done pathetic for the institution, and several other things. So the question arises that whether someone should, and just see the plight of even on the Supreme Court. Supreme Court being the protector of fundamental right of the citizen, being the utmost court for the protector of fundamental right of the citizen, and if any member of bar make a direct statement against a sitting judge or against the entire institution, whether some action is not needed in this kind of situation. And therefore, in the light of all these facts and circumstances which exist and which prevail in this very case, we all feel, and as far as myself is concerned, I certainly feel that certainly some stringent action must be taken in this case, because it is apparent violation, apparent defiance, and apparent attempt to diminish the image perception of the Supreme Court of India, which is the highest court of this land. And rest all, being myself as an 11th speaker, for me it is really very less to say, because at least I will only reiterate what has already been said by all high and mighty people, which all were there today evening. So once again, I tender my heartiest thanks to everyone for giving me an opportunity to say and share my personal view to everyone. So thank you.
Thank you, Balenduji. Thank you for being short. And now, I once again thank all the speakers. Now, I'll ask Mr. Ankit Raj to give vote of thanks.
Thank you, Adunama ma'am. Good evening to all learned senior members and friends from the bar. On behalf of Delhi Advocate Group, I deem it great honor and privilege to propose the vote of thanks on this enlightening session on a very fundamental issue pertaining the bar, independence of judiciary and role of bar. First and foremost, I thank our distinguished legal luminary for sharing their time and valuable words with us. Mr. R. Venkataramani, learned senior advocate, Supreme Court of India and former member, Law Commission of India. Mr. V. Sekhar, learned senior advocate and former vice president, SCBA. Learned senior advocate, Dr. H.P. Sharma ji. Mr. Dinesh Agnani, learned senior advocate. Mr. Vivek Sood, learned senior advocate. Mr. Vivek Reddi, learned senior advocate. Mr. Ajit Kumar, senior advocate and former advocate general for the state of Jharkhand. Mr. Vikrant Yadav, learned senior advocate and former secretary SCBA. Mr. S. N. Sharma ji, advocate. Mr. Ajay Singh ji, advocate on record, Supreme Court. And Mr. Balendu Sekhar ji, advocate. I also thank all the invitees, friends, and senior members of the bar for their valuable time who have virtually participated in this webinar from across the country. Special thank to all the members who have worked behind the screen for making this webinar a resounding success. Last but not the least, I thank Mr. Ripudaman Bhardwaj, convener, Delhi Advocate Group, Mr. Ajay Dikpal, Dheeraj Sir, Madam Arunima Dwivedi, advocates for their active coordination in organizing this webinar possible. Once again, I say we are all truly inspired by your great words. Thanks. Back to you, Arunima.
Thank you, everybody. Thank you. So we close our meeting now.
Thank you.
Thank you.
Thank you all. Thank you all.